Assalamu alaikum and hello to everyone. Welcome to the 60th session of LUMS Live. We are here today to discuss a recent decision of the Lahore High Court, which has declared virginity testing, including the two-finger test, for the examination of sexual assault survivors illegal and constitutional. In her judgment, the Honorable Justice Aisha Malik said that virginity testing is highly invasive, having no scientific or medical requirement, yet carried out in the name of medical protocols in sexual violence cases. The judge directed the federal and the provincial governments to take necessary steps to ensure that the virginity tests are not carried out in medico legal examinations of victims of rape and sexual abuse. My name is Zehra Zaidi, and I am joined today by a distinguished panel of legal practitioners and academics who were deeply involved in filing this writ petition and challenging the two-finger test. I'll begin with introducing the panel. We have here with us Dr. Sadaf Aziz, who was one of the petitioners in this case. Dr. Aziz is Associate Professor at Dean of the Sheikh Ahmed Hassan School of Law here at LUMS. She has taught in areas of jurisprudence, labor, constitutional law, and her research focuses on the interplay between Islam and secular legality, and has authored a book, The Pakistani Constitution, A Contextual Analysis. So thank you, Sadaf, for being here with us today. We also have Maria Farooq, who is a partner at Access Law Chambers and adjunct faculty at SASL. Maria is an advocate of the Lahore High Court and has worked on many commercial arbitrations and provides advice to multinational corporations, global telecom operators, and financial institutions. I'd like to explain that there were two petitions filed in this case. One was filed by Maria and her colleague Samir Khosa, who is also a partner at Access Law, and Samir is here with us today. He has also been adjunct faculty at LUMS and is an advocate of the Lahore High Court. Samir works on constitutional and commercial matters and represents both the public and private sector in a wide range of cases. The second petition was filed by Ms. Sahar Bandial and Mr. Hammad Saeed. And may I add that both these petitions were clubbed and heard together in court. And Sahar and Hammad are both here with us today. Sahar is an advocate of the Lahore High Court, also adjunct faculty at SASOL. She litigates in areas of constitutional, civil, banking, labor, and family law, and has a keen interest in gender and law. Samar and Hammad also co-authored the anti-rape bill, which was passed into law in 2016. And Mr. Hammad Saeed is a criminal defense lawyer with over a decade of experience before trial and high courts of Pakistan. He has been on the defense team of many high-profile cases, and at LUMS, he teaches criminal code and procedure and supervises the legal aid clinic. So welcome and thank you all for taking the time to be here with us today. I'd like to begin, Sadaf, my first to you. I'd like to begin. And this was a very specific, targeted piece of this litigation. However, its repercussions are broad. I'd like to ask, how was the experience for you as a petitioner in the process? And could you speak about the model that has been developed with respect to public litigation in this particular instance?
Okay. Thank you, Sarah. So I think, so I'll just broadly sort of situate that, what you're saying. So you've suggested it formed a model for a certain type of public interest litigation. And so it's a petition filed under Article 199 of the Pakistani Constitution, so therefore addressed or placed at the level of the High Court. And what that allows people to do is that an aggrieved party can seek redress or a remedy in cases of violation of fundamental rights. And so the nature of public interest litigation, not only in Pakistan, but in the region, has been that the definition or the notion of who an aggrieved party is or who has standing has expanded considerably. So while myself and there were a total of 8 petitioners in this petition, none of us was directly impacted or suffered harm consequent upon the enactment or enforcement of this form of medical legal jurisprudence, the tests that have been in place now for a very long time in the history of the subcontinent, particularly. We have an interest in seeing that the practice be abolished. And the fundamental rights that were made the judgment in this petition were, broad panoply of rights. So it included Article 9, which is security of person, the guarantee of life and security of person. Article 14, which is the guarantee of dignity, individual dignity, inclusive of the right to privacy. And Article 25, which is the guarantee of equality of citizens, right? And has a specific bar on gender-based discrimination. So for me, all of this was obviously very important. I mean, as it is for the broader citizenry, and I think particularly vis-a-vis the kind of pushing the envelope on the interpretation of Article 25 and challenging, discriminatory practices. This forms a kind of really interesting piece of a puzzle, particularly when it goes to taking crimes against women or taking sex-based crimes seriously. Right? I think that it did a lot of things insofar as it allows one to kind of disaggregate what we see as a kind of unwillingness to take these crimes seriously, is that it unfolds precisely what it is in terms of the procedural aspects of the law in function, which dissuade women from filing for making complaints of rape. And it shows up how much discrimination and trauma they will be subject to once they have filed a complaint of rape. So there were all of those things. I think broadly, though, the experience, coming back to the question of how this forms in some ways a kind of template for how to do public interest litigation well, and for this all the credit goes to the advocates involved, is that as petitioners we were involved at multiple stages of this process. So we were given repeated drafts of the petition to look at, and to feed into. We were consulted vis-a-vis the broader kind of public strategizing around the petition, the messaging that went out, how narrow, how broad that was at various points. Also, at various stages of the trial, when, for instance, when the government of Punjab came back with the issuance of a certain set of revised standard operating procedures, which went to the collection of this kind of medical evidence, we were consulted about how far to push back because they were claiming necessity for effectively the perpetuation of these practices. So it was just a deeply insightful experience for me, both because of the expertise of the advocates involved, the degree to which they were carrying out very in-depth research, looking at multiple jurisdictions, looking at international standards and advocacy, as well as thinking of alternatives, right? And a lot of that also then had to do with the expertise of the other petitioners on the case, many of whom have direct, whose life work really is dealing with female or victims of sexual crime. And the trauma that they suffer, and they're involved in counseling, or they've been involved in various levels of advocacy before this. So in those ways, I do think that it was just an exemplary set of practices that went into the filing and the carrying out of this petition.
No, thank you, Sadaf. So it seems as if, that the petitioners in this represented a cross-section of society. And I think what's important to recognize is that one doesn't have to be a victim or to be affected by any particular law directly. You can just it's important to know that public interest litigation can be filed on behalf of concerned citizens who want to see a change in that area. So thank you very much for that. I'd like to move on and speak to Maria and Samir first. And if you could tell us a bit about the history of the test and sort of, the timeline, how your interest developed and what sort of prompted you to file the writ petition, and and sort of tell our listeners why was there this need to go to court. And I know I've addressed it to both of you, so I don't know, Maria, if you'd like to go first, and Samir.
Simi, do you want to go first or should I just go ahead?
No, no, go ahead.
Okay. Um, so I think in terms of the history of the practice, it is something that we ourselves struggled with when we were trying to figure out what is the source of this practice. And our interest in this issue was there in terms of there having been literature on this topic already. There are people in Pakistan, women who've written upon it. But we saw that there was no sort of legal action which has been taken on this matter. Back in 2018, Soch, which is sort of an online platform that raises issues of social awareness through digital media, had made a video on this practice and how this is conducted. We sort of use that as a basis to see currently this practice is going on, and then further developed on that issue, looking at what was the source of the practice. And what we did figure out that this practice is something that is from coming from the colonial era, where the character of the woman was of paramount importance. There was this societal impact of whether a woman is chaste or not. And that's how this practice found its way in cases of sexual assault. Later on, when we looked further into it, we figured out that there are SOPs and instructions that have been issued by the government of Punjab Health Department, wherein this practice is mandated in cases of sexual assault. Essentially, the practice that both the petitions had challenged were those of virginity tests, and there were two forms of the test. There was a two-finger test, and then there was a hymen test. And the idea behind that test was that if there's a determination through the test made about the virginity of the woman, then a determination can be made as to whether an offense of sexual assault has taken place or not. And Samir can build onto it, but essentially what we were looking at was whether there is any a medical basis as to the determination that is taken from this test. Is it conclusive or not? Is it correct or not? And the second, whether there is any legal basis for this test, aside from the SOPs and the manual that we had figured out the government of Punjab has issued.
Yeah. Maria, if I could just make a comment over there, and I'm trying to get my head around this. So if the hymen was found to be intact, then the allegation of rape becomes questionable. Whereas if it's broken, then it raises assumptions and questions as to the chastity, and you said the character of the woman. So, this seemed like a complete, for the audience to understand, seems like a complete no-win for a woman if you were to look at it that. And perhaps Samir, if you wanted to comment on that further.
No, I think that's exactly right. So that's the catch-22 that you find yourself in.
Exactly.
You're either not credible because you had bad character, or you're not credible because there's been no penetrative sexual activity. So that was the fundamental conception that we had to kind of address, was whether or not there is a medical or scientific basis for the test, right? Does it lead to a medically reliable or a scientifically reliable conclusion, either about whether penetration has taken place or about past sexual contact? and the literature around that and the consensus, the medical and scientific forensic expert consensus around that globally is that it does not. That's the fundamental misconception on the basis of which the test continues to take place. Apart from this idea of what a morally chaste woman looks like, or sounds like, or behaves like, there is this idea that these practices contribute to some understanding of that character, and that link has to be broken. They don't. So that was the first part. And the second part is that even if they did provide you some information, are they relevant to an allegation of a particular offense, whether that took place or not? And of course, previous sexual activity is no marker for whether or not there was consent in this particular instance. That's the second fundamental misconception that had to be kind of tackled. And both of them are tackled very comprehensively in the judgment itself. I just want to go back to your original question, which was that why did we end up going to court? And I think it's important to point out that the case against, or the societal case against the carrying out of the two-finger test and virginity testing is not new. It's a pretty long-standing issue, a demand that has been in our society. But I think what we found was that while the political, sociological, human rights case for it was pretty strong and was made in very many forums, that had not really been translated into a legal rights-based case. And so when we looked at it and we started looking at the practice, we thought there's a real case here for why a constitutional court could look at it, and rather than rely on new legislation itself, it's a practice that, as it stands currently, violates the rights of dignity and privacy and life and access to justice. And a constitutional court can look at this issue. And so our challenge really was trying to frame the argument about what we were asking from the court in precise enough terms. And I think that's where we started exploring the idea and looked at whether or not a successful constitutional petition could be brought. And Sadaf, for example, was instrumental in helping us figuring out the history of the test. So that's where our petitioners and the cross section of society really, it was a real expertise kind of being pulled together. So I think if there's something about the model to be said, I think it's a model for why civil society and academia and practitioners can kind of come together to work in some kind of focused manner. I think that's the kind of sense that I have of this episode.
No, absolutely no doubt. But then just moving on to Sahar and Hammad, I mean, you also sort of had to work precedent that existed on the matter with respect to the test. So could you elaborate on, within judgments, what was the use of language around the test within judgments that existed within precedent? Was it largely relied on by judges? Did the law support the test? And what did this mean for a survivor if a judge is going to be talking about the two-finger test in the judgment? What did this mean for the survivor? And were there any dissenting voices? Were there others saying that this is wrong, it needs to be scrapped? So if you could talk about that, Sahar and Hammad, please. Maybe Sahar first, and then
Sure. Um, Zara, the use of language we see is pretty similar across a range of cases over several decades. So it goes something to the effect of the vagina admits two fingers, the hymen is not freshly torn, or the hymen is old torn. The woman could be a woman of easy virtue, or this is a woman who is habituated to sex, and therefore her sole testimony is not reliable. So this is language that judges would pick up and reproduce in their judgments, relying on the medical legal reports provided to them. I mean, I can read out a particular excerpt which I found particularly uncomfortable. This is 2008 YLR 2846. And I quote, the medical report also reveals that the hymen was torn, which was old healed. Vagina admits two fingers. Victim appears to be a woman of easy virtue, and her sole statement cannot be relied upon. So that's the kind of language which is used. And you ask, what is the effect of, such sort of conclusions drawn in judgments? and this is something you alluded to earlier, and Samir also commented on it, that there's now a dual burden on the rape survivor. At one, she has to prove her case, prove the prosecution case that the rape was committed. And additionally, she has to prove that her testimony is confidence inspiring. Otherwise, it's the defense who has to, question her testimony, question her credibility. But now she carries a dual burden of proving both the fact that the commission of rape occurred, and secondly, that she is a witness whose testimony is worth believing. So that was the dual impact of this sort of presumption which emerged in the law. You asked about dissenting voices to Zehra, and this is something that Justice Aisha also refers to her to this in her judgment. There are two or three Supreme Court judgments, one from the 80s, the other from 2002, and again sometime after 2000, where the Supreme Court has held that there is no presumption in the law that a woman of easy virtue may be raped without any limitation, that she's given free invitation to anyone to just, sorry, sorry about that.
No, it's fine.
So, Zahra, do you want to carry on? And I'll just come back to you.
Yeah, sure. Hammad, would you like to take over?
Yeah, so the two-finger test is part of like an old defense strategy, right? Which is that you go after the character of the victim, and that goes directly to credibility. So a victim who is habituated to sex or of easy morals or easy virtue, as the language has been employed, is more difficult to believe. And
Yeah.
the law actually in this medical test helped the defense find, discover an argument and discover a medically, in that era, sound argument for the basis of character assassination. So just the fact that the 2016 amendment came in and it barred questions about the character of a woman, that was the first step. So with that line of questioning closed for the defense, when character assassinations become irrelevant or are not allowed in trial courts, it is there that at least a part of the two-finger test starts to become irrelevant for the defense. And the fact that they could just piggyback on medical evidence to introduce such character flaws in victim testimony, doing away with it became extremely important, because you can't allow, it was a backdoor to a defense that the law doesn't no longer allow.
Yeah, no, absolutely. Thank you for that, Ahmad. And I just wanted to, before I proceed, just to understand a little bit more about, what was happening on ground. So, Amari and Samir, if you could just tell us a little bit about the timeline of the events, and when once these petitions were filed, the position that was taken by the respondents and the federal government, because it seemed as if there was not much resistance. But if you could sort of talk about what was happening and over there in the court. Yeah, so please.
Okay, fine,
Samir,
I'll start. Yes.
would you like to talk about that? Yeah.
Sure. So the petitions were filed in the first half of 2020, March for us, I think April or June for Sahar and Hammad's petition, somewhere around the early part of 2020. The provincial governments and the federal governments were asked to file their reply. And I think till about the summer, no replies were coming, although we had the SOPs that that we'd been challenged, and they kind of placed the SOPs on the record. Around September, the provincial government made a statement in the court that they support the abolition of the two-finger test, and that they, in that sense, in principle, they agree with the petitioners in the case. The federal government had still not taken a position in court. The court asked the provincial government to do two things. One, it was to file their reply in court that would clarify their position. And the second thing that the court asked them is that if there is support for the abolition of the two-finger test, then they should place mechanisms and steps that they have taken to actually abolish the test in the time period, if that's their position. So then the case was adjourned. Sometime in October, when 4 weeks later, when the case was filed, the Punjab government did file their reply, and the Punjab government's reply. So it was a bit equivocal in the sense that although they had stated publicly that they support the abolition of the test, if you read the reply, they were kind of asking for still a way to carry out the test in certain situations, which were too vague to be reliable. In that, if you were going to go around, if you could perform the test. In case of injuries, to detect injuries. Then there was this other idea that the Hyman test would still be carried out because it has relevance to whether or not there has been recent sexual activity, and you have to report whether or not the woman was a virgin or not. So we realized that the position that had publicly been taken and the position that had been taken in writing were vastly different. So that's the case then, and on both of our petitions, we tried to bring to the attention of the court that this was taking place. The Punjab government then tried to file revised guidelines, which were a little more certain about the abolition of the two-finger test, but the architecture of the guidelines was such that, again, it was not clear. And we, again, submitted comments to the court about why the guidelines were not sufficient. The federal government, in the meanwhile, the court at one point in time asked the Punjab government that, it's been 6 weeks, 4 weeks, you'd asked for 6 weeks time. Why have you still not been successfully able to issue new guidelines or make new legislation, which is what prompted the kind of hastily compiled guidelines that they filed and notified in around November. The federal government took the position that they supported the abolition of the test, but that was about it. But the Criminal Procedure Code and matters of criminal procedure are both federal and provincial subjects. And as we saw with the anti-rape ordinance when they promulgated it, the federal government could easily have acted on its own to abolish and affect criminal procedure, this kind of test. So it was clear, I think, 2 or 3 things that caused the provincial and federal government's position to take place. One, I think it's unmistakable that we had these 2 petitions in court and the court was asking them to take a position on it that forced them. And second, of course, is, incidents of rape that took place in the fall of 2020 that made the news as well, which were particularly heinous. And I think it kind of forced the issue in public consciousness around the same time, which made it imperative for the provincial and the federal governments to also not only act, but to be seen to be publicly acting. And I think around that time, they decided that, yes, they would support it. But, there was still, even till the last hearing, there were elements, the Office of the Surgeon Medical General were making the argument for why the tests are relevant. And we had to make the arguments in court about whether or not this was medically or scientifically reliable, whether it was relevant to a rape investigation. And those are the arguments, in fact, that have been tackled by the judge. If there was no resistance, you would have had a judgment that said that the provincial and federal government support the test. But we've already seen the judgment tackle a lot of arguments that were presented both inside the courtroom, in writing, and sometimes, verbally.
Sorry, I'm just going to ask you all, is it just me or are your internets patchy? Were you able to hear Samir clearly throughout? Okay, so sorry. Okay, so it's probably on my end.
Thankfully.
Sorry. Anyway, but I think I got most of what you were saying, Samir. So Sahar, going back to you, so as Samir explained, the SOPs came rather late in the day, and especially when the judgment had already been reserved. But could you talk to us as litigants and researchers, what were the lacunas in knowledge that arose, which meant that you had to seek across to experts in other fields and internationally, which helped you frame your arguments? So the sorts of research and the help that you got in writing the petition, in writing the reply, because I know you all worked together to supply the reply to the SOPs. Yeah.
So Zehra, there were actually 2 things. One were the new guidelines that were issued, and we were in a bit of a rush to respond to those and articulate our objections to those. And the question that we really had to creatively think about is that if we are to do away with both the Hyman test and the two-finger test, which have been used in our jurisdiction for decades, what alternative are we providing? What alternative mechanisms will be used during the course of medical legal examinations? And Hammad was very helpful in this regard because he has experience of criminal trial in rape cases. But we also looked at and talked to forensic science experts here, and then reached out to other lawyers who had been involved in trainings of medical legal officers and had worked on this subject. So that was very helpful to allowing us to immediately work towards replying to those guidelines. But we were also asked by the court to take a larger international perspective and provide information about how these tests are carried out in other Muslim jurisdictions. So we looked at Malaysia, Indonesia, Afghanistan, Bangladesh. We also looked at the US and the UK to seek information about procedures in other Muslim countries. I contacted Musawa, which is an NGO based in Malaysia, and it sort of has a really strong link with other NGOs in Muslim countries, women's NGOs in Muslim countries. They were very helpful in providing information. And others reached out to, practitioners in other areas. So, that was a point where we really spread out and reached out to our various connections. And I think got help from all fronts, from experts based abroad, experts based here as well. So really, it was a collective effort at that point. We were pooling our own strengths, our own resources, and then those that we had access to on an individual basis.
Yeah. And Hamad, in terms of the practicality of the criminal trial, could you talk about the difference the abolition of this test will make to the way in which rape is investigated? I mean, is the barring of this test enough for the survivor? Um, Perhaps you could comment on, what other parts of the state apparatus need to be changed to make not just investigations, but also the hearing process more survivor friendly. Because, right now, the way, as they say, the victim or the survivor is it's as if they're raped twice. Once when the incident itself happens, and then once during the trial. So, this is no doubt this is a big step, but is it enough? What more changes would you like to see in the system?
I mean, I think it's an essential step towards providing the victim a more dignified route to seeking justice. They are prosecution witnesses. They need to be afforded every protection that we can afford them. And I mean, with the two-finger test, I mean, the balance is between providing a victim essential medical health care to which they will almost always consent, versus collecting evidence to form the basis of a criminal trial. And I think at that point, to force victims to undergo like procedures such as the two-finger test, violative of dignity, which have the potential to be used against them at the trial, that placed a huge cost on a victim who was in some cases just there to seek medical facilities, to seek basic healthcare requirements. So I think the fact that the two-finger test has been done away with and the 2020 guidelines have been done away with, it allows the government and civil society an opportunity to engage with each other, to understand and perhaps determine the scope of what services should be offered to sexual assault victims who are approaching medical officers. To what extent should their consent be involved within those medical procedures? And considering this is one of the first 2 or 3 things that are happening with a victim, if they are made comfortable at that stage, if they are made to understand that cooperating with the investigation or being part of the investigation is something that won't open up an embarrassing line of questioning for them, that builds more faith within the legal system. And this is a part of a very significant overhaul that has to happen. So I mean, one of the biggest challenges that happens with medical examinations is whether doctors or the attending staff are collecting and protecting evidence in a manner that is conducive for it to be used at the trial. So with the introduction of DNA evidence and the value it has, it's become all the more important that medical staff, when conducting these examinations, take the opportunity to properly secure and tag evidence that they don't allow it to be mutilated or any such thing that may cause the evidence to lose its value. So I think the fact that the two-finger test has been done away with and the 2020 guidelines have been done away with has offered an opportunity for us to look at these processes much more in depth. Like the documents are now public, anyone can access them, and propose and introduce changes. At the end of the day, this and strike a balance between the medical facilities that need to be offered versus the evidence that needs to be procured. So, I mean, one of the key discussions that me and Sahar repeatedly had was of how certain jurisdictions allow for examinations to be done that are undignified in some ways constitutionally, but they're done with specific reasons and specific causes. So, and medical forms that require such causes or such reasons to be recorded by the attending physician. That is something that we wanted included, that we thought that was very important, because you shouldn't be compromising on the health of a victim in order to protect evidence or in order to preserve evidence. So that's a balance that we need to be working towards. I mean, overall, the investigation requires overhaul at several places, but this is a good stepping stone.
Now, is that my internet or
A
Hammad's?
part of the two. Oh, sorry.
No, that's fine.
Yeah, I mean, with the 2016 amendment, some of the 2020 amendments, not all of them, I think we are creating a safer and securer environment for victims to approach the police and approach medical practitioners. There's a lot of work that needs to be done subsequent to that approach, so that good, plausible evidence can be collected and presented adequately at trial.
Yeah. So I'll come back and talk to you and Sahar about the interplay between the 2016 Act and the 2020 Ordinance. But a question for you, Sadaf. This test has been there for decades, but it's only now that it's been challenged. So your views as a petitioner, what is it that you think propelled and allowed for this sort of a discourse to take place in open court now, and say not 10 years ago? What changed?
Sorry, so you're asking the question of why was
Should
this?
Should I repeat the question? Yeah.
Yeah.
So okay. So all I'm saying is that the test has been there for decades, but it's only been challenged now. And as the petitioner, in your view, what is it that propelled and allowed? What are the reasons that propelled and allowed for this sort of a discourse to take place now, as compared to, say, 5 or 10 years ago? What changed that we're having these discussions now? We're able to do these sorts of panels, and I mean, I know a part of it is, of course, the recent heinous acts of sexual abuse against against young children, and of course the motorway case. But other than that, sorry, you can't hear me, or can you?
I can hear you now, but
Okay.
I mean, it's cut out a bit, but I mean,
Okay.
I understand what you're saying.
Okay.
So in terms of the broader, I mean, I think that a great deal has changed in a broader public social sphere in terms of the ability to discuss these issues. First hearing, and Samir and Arya will recall, and the judge, took the file and sort of, asked the advocates to come forward and didn't really want things discussed in an open court. And it was really interesting because it seemed like, she kept on saying, okay, where you're making this argument in your written arguments and like, can you instruct me to specific paragraphs, asked a few questions, and then went away. And so there very much was in that initial hearing this kind of slightly, shrouded sense about, the extent to which a kind of explicit discussion of the violation of female anatomy would be, which is integral to discussing this issue, of course, right? So what has the, which is not to say, obviously that doesn't carry over. The discussion in the judgment is open, frank, has to be, makes reference to all of these things and reflects very deeply upon them, upon the kind of mythography both of good and bad women, honor, dishonor, as well as the mythography of what female anatomy is and how modular it is in some male perception, which has obviously carried forth for decades and decades, right? And emanates again from again just a kind of mythologized sense of what that female anatomy is, and has been ratcheted up and invested with all sorts of other moral attributes. And so it discusses all that, right? It discusses the fact that there is absolutely no particular shape, size, opening, which one can call an intact hymen. Or one which has been torn or violated. It reflects on all these things. But going back to I think, Samir referred to it earlier, that obviously there have been particularly heinous crimes in not just, certainly in the last year with the motorway rape case, but prior to that also instances of child sexual abuse which have come into the public sphere, which have been discussed, vigorously. All of these things, I think that a certain amount of female advocacy, I think that there are a great number of women who have been doing this, as their life's work, but the kind of collectivities that have arisen in the last few years, again, in this kind of resurgent fashion through, the Aurat March and the like, which absolutely, and it's going back to that kind of second wave feminism of, the personal is political, and also the personal has to be able to be discussed in frank and open terms, because of course all sorts of patriarchal constructs and all of these things impact the lives of women in what we putatively set aside as their kind of personal sphere, and therefore we shroud them in secrecy and make them untenable as modes of, as kind of harms that they have suffered, which deserve, some kind of state redress mechanism. So I think that all these things have happened, over the last few years, particularly. It's just the vibrancy of the media, social media, all of these things in combination have allowed for there to be open and frank discussion about these things. And I think, yeah, sorry, I was going to make a kind of, further tangential point from that, but actually
No,
go
but
on.
please go ahead, because all of this makes sense. Social media, the visibility of, sort of Aurat March and societal change, all of it together, yeah, it allows for this sort of a discourse. And yeah, sorry, would you like to continue? Yeah.
Sure. Just one point that I wanted to fit in, and it's interesting because I haven't had a chance to discuss it with the advocates, and the people who worked on the case. But one really quite promising thing that I see from the judgment is that, in terms of the Article 25 discussion, of course, there's been a finding of discrimination on the grounds of gender, because, of course, you have categories. So you have male victims and then you have female victims. Of course, it's only female victims that are being subject to this particularly invasive and violative practice. But what's also interesting is that in terms of the kind of categories of, honorable, chaste women versus, those who are habituated to sex and therefore susceptible to be lying about the crime. It's really actually hinged to a certain kind of interesting legal analysis that the judge has undertaken, which is that you have this kind of unreasonable classification that is working itself out vis-a-vis women as well, not just in the performance of the test, but what the further repercussions of that test are. So in terms of the inequality of the operation of, official acts and the like, it puts women in, quite differential circumstances, those who are found to be virgins against those who are not found to be virgins. And thereafter, how their testimony, as various people on the panel have already, asserted and drawn attention to, how their testimony is likely to be received in a courtroom, and all of those things, right? All the further repercussions of drawing that distinction. And that itself is a kind of violative act. And I think that that's a kind of interesting and promising line of jurisprudence on the basis of which, hopefully not only vis-a-vis sexual violence against women or sexual crimes broadly, but women's access in differential positions to other rights, whether those are reproductive rights, education, things like that, how these kinds of differentiations might be drawn. But again, like I was saying, that's somewhat a kind of tangential point to what you were asking, but I see that.
I see your point that this could be the stepping stone to all of that. I mean, this is to look forward to in the future. Those are other sort of aims to work towards. But just a question for Maria. I mean, we're talking about discourse and commentary and discussions. If you were to read the comments, I'm sure you have below any newspaper article or opinion piece on this. I mean, people tend to ask that what's going to happen now? How is rape going to be proved now? How will we know that the woman is not lying? I mean, it comes up all the time. So how would you respond to them?
Thank you. And I think, thank you, Sadaf, because I do agree with the aspect of Article 25. And that also goes on to sort of certain deficiencies that we pointed out in the guidelines when it didn't really address what about married women or what about sex workers, right? So I think that kind of classification and the dangers of that are for women who are not virgins or, if, for example, prostitutes, etc. And Zehra, coming to your point, I think it's also important to see that even in the judgment, it's written that any form of medical examination is not supposed to determine whether the offense of sexual assault has taken place or not. So the premise that by virtue of this test, you can determine whether sexual assault or rape took place was incorrect. And the second sort of response that was received during the process of the petition, whereby there was a reluctance on the ground that no, in certain circumstances, this form of testing is necessary, was to come to the point that this form of a test was never supposed to be under a medical analysis ever determine whether rape had occurred or not. It was essentially irrelevant to the question that is before the court of whether that act had been committed or not. So when the response is that now you take this test out of this medical examination, how can the offense of rape be proved? To begin with, it was never necessary, because all that these two forms of test, which is the two-finger test and the hymen test, were to determine on the basis of the status of the hymen or the laxity of the vagina as to whether a woman is a virgin or not, or has been involved in past sexual activity. And that in any event is not a condition or not sort of one of the factors that need to be proved for the offense of rape. So the offense of rape, which is in Pakistan Penal Code, section 375, doesn't mention this. The sort of one primary element of that is whether there was consent to that act or not. And if there has been a forced sexual intercourse, then that would qualify as rape. And to the extent of why would this test ever be necessary, the purpose of medical legal examination would be either the inspection or detection of injury or for collection of evidence. And the literature that we brought before the court, and what all four of us, including and the petitioners, we studied, was that this particular test doesn't address any of those things. And what we actually did submit, which Sahar was saying, that we had to look at international sort of sources. We looked at Malaysia, Canada, US, UK, and none of those particular jurisdictions mandate the test. So even sort of looking at all of these jurisdictions which have specific guidelines on sexual assault, don't mandate this test or recommend this test, is furthering our point of view that the test is not necessary, and the determination of whether the offense of rape has taken place was never going to be through this test. And what we have in place and what we should have in place are other procedures, other sort of evidentiary requirements that will go to prove whether the charge is false or not.
Yeah, no, no, thank you for that explanation, Maria. And I, if one of you could comment on, the notion of consent, please. And so perhaps, sorry, I should direct this. Perhaps, Hammad would be able to, would like to answer this. The notion of legal consent, and I'm just trying to understand with respect to the previous law. Well, not the previous law. I mean, the 2016 Act and the current law. Has the understanding of consent changed? Has there been any developments? And Sahar, if you could also comment a little bit on, sorry, I'm just mindful of the time a little. If you could comment on your and Hammad's involvement in the 2016 Act. And now we have this new bill. How is it all going to play out? So, yeah. Did my voice cut off again? I'm just Sahar, you're on mute.
Hammad, do you want to answer the question on consent, and then I can take up the question on the legislation?
Possibly I think Hammad is probably having internet connectivity issues. Oh no.
Should I go ahead then?
Yeah, sure.
Sure. The idea of consent, Zehra, has, I think, somewhat been refined, I would say, in the 2020 ordinance in two primary respects. In one respect, the ordinance has clarified that where the victim is under the influence of, drugs or alcohol or any other substance, by reason of which she's unable to understand or communicate her consent, that will be a situation where the law will presume that there was no consent to the sexual activity. Second, the law has also categorically provided in an explanation to the amended Section 375 that where there are an absence of injuries, the fact that there are no injuries or there are no signs of physical resistance on the body of the rape survivor, the law will not presume that there was consent. And I think this is extremely significant because we had a series of judgments where the courts had observed that there are no signs of injury, there are no signs of resistance, and that then would be used to conclude that there may have been consent to the sexual activity. There are other SOPs that we looked at, Hammad and I, earlier on when we were in the process of, drafting the petition, especially the Indian SOPs and guidelines for sexual assault survivors, which categorically state that the absence of injuries does not mean, or the absence of any signs of resistance does not mean that there was consent. And even at that point, we wondered whether we should specifically make a pleading to this effect in our petition, but then decided against it. So I believe that the 2020 ordinance is very significant in this particular respect, that this aspect of consent has been clarified. And when it comes to the interaction between the 2016 and 2020 law, At one, I think the 2020 law has moved forward. The ordinance has moved forward the law of rape in terms of how it defines rape. So even in 2013, when we were drafting the amendment, Hamad and I talked about whether we should include object rape in the definition of rape, whether we should include a non-consensual penetration of other bodily orifices in the definition. But then we thought that, maybe this will raise too much controversy and let's hold back on this. This the 2020 ordinance does. So now that the definition of rape has expanded to include object rape, a non-consensual penetration of other bodily orifices other than the vaginal canal, it has expanded the definition to make it gender neutral. So now transgenders and men can equally be victim of rape as women. Earlier, the definition of rape was such that only women could be victims of rape. Also, what's happened is that even oral penetration has come within the definition of rape. So, in that sense, the 2020 ordinance has moved the law forward. This is something we wanted to do in 2013, but then decided against it. And maybe I let Hamad, because there's a shortage of time. Maybe Hamad can comment on some of the provisions of the 2020 ordinance, which actually just merely replicate what was already passed into law in 2016. So I'll let Hamad take over now. Can't hear you, Hamad.
Sorry about patchy internet. Yeah, and thank you, Sahar. These are some of the provisions, like so either 2020 though amendments, and one of them goes to the definition of rape, which Sahar is right to point out is moves things forward in a very significant way. And that's actually crucial to expanding protections under the PPC, and that's a great part about those substantial amendments. Procedurally, we're not actually too sure. I mean, the procedural amendments include the establishment of special courts that hear rape cases. Again, for the past, I think, 4 years, we've had special case courts in most districts, which have been labeled as gender-based violence courts, where judges have been conducting trials in a manner that is conducive to witness and victim protection, where child witnesses and victims of sexual offenses are treated in protected ways. So those provisions have existed. The new ordinance merely replicates some of those protections. Similarly, you have the Punjab Witness Protection Act that affords certain protection to witnesses in terms of how they can be examined if they're being approached outside of court. The rape law amendment ordinance, again, the procedural one, looks to replicate some of those provisions. Of course, the ordinance will be applicable all throughout Pakistan, so that's a good thing. But we're not sure about how the two provisions will interplay with each other. The ordinance also bars the two-finger test. That's already been done. It says that you can't ask questions related to the character of the witness or the character of the victim. Again, this is an amendment that was pushed through in 2016. And it's, I think, one of the most valuable amendments that have come through, considering this changes the scheme of the Qanun-e-Shahadat order. So, I mean, there's certain tension over there about why the government wouldn't want to take a deeper look at the Qanun-e-Shahadat. So the 2020 ordinance doesn't do that as much in depth. Oh, I think I've about bad internet again. Oh no.
Zehra, we can't hear you.
There may be a problem with your mic.
Can you hear me now?
Yes.
Yeah? Okay. Hang on. It's so funny that I can't hear you, but you can hear me. That's fine. Well, sorry about that. It was, I don't know, technology just slows us down sometimes. Okay, so yes, we're coming to the end of of our time, and perhaps I can end with you, Samir. And you know, I've already we've spoken about this earlier on, especially with Sadaf, but no doubt this is a big development, a big reform in the law. But the practice has been banned, but has the issue been resolved? Have the mindsets been changed? In the broader scheme of things, you know, a lot more needs to be done. Um, what do you think? What's the next step going forward? Not just, and I'm not just saying what in terms of what you would want to do personally. As what would you like to see from you know, legislatively or in terms of you know, activism on this issue? What do you think this would be the second step? What would be the next step in making it better for the survivors even more?
Thank you, Zaira. I think it's, as you said, I think it's important to recognize that while this is a significant step, it is just that, it's one step. And I think it's important also, and I think the thing that we need to work on is very evident from, you know, your earlier question, which was the question we received most often, which is what will we do now, right? And I think you keep having to tell people that what we'll have to do is not rely on lazy assumptions anymore, and actually do the work of collecting evidence. And that's the issue. There's so much lack of awareness around a criminal procedure, criminal investigations, what goes on into a rape investigation. And so one thing is that we need to raise awareness about what it means to investigate rape and sexual offenses. The second, I think, is a larger project, which is about making the justice system accessible, not just for women, but for people, like economically backward people. You know, the justice system is inaccessible in this country for many, many people, including women, in very, very grave ways. And that's work that we need to do. The third is that, you know, even little steps in this area, for example, two very obvious things come to mind. The judgment says that we need to make the federal and provincial governments need to make new protocols. And if we compare what protocols have been in our country versus what they've been just like internationally, there's a huge gulf. Questions about whether or not what you wear, where you, what do you do, are routine for medical legal examinations in Pakistan. Whereas, you know, any guidelines talk about how do you get meaningful consent, what it is to make a victim comfortable. You're often their first point of contact after a particularly traumatic experience, how best to elicit response, what it means to kind of, sensitively ask them questions about what has happened to them, what the purpose of a medical legal exam is, to examine the state of the body and to provide medical care, not to make assumptions about what she says happened or did not happen. That's the role of the court. So I think that the judgment is one step in addressing some of these assumptions, and those assumptions need to be aggressively countered. I think that, you know, judicial academy trainings need to take place because these matters will still need to come to court. Those medical legal procedures need to be improved and worked upon. I think that broader argument about what it means to consent needs to be, aggressively made. And those things will continue. Those efforts will absolutely continue. This judgment enables us to make this argument a little bit more forcefully. It covers some ground that, you know, we've been covering. But over the last 13 years, between the Protection of Women Act in 2006, the Supreme Court judgment that mandated DNA evidence, the 2016 amendments, this judgment, now 2020, there have been steps over the last 15 years. You can see, you know, there is a progression, and that's what we need to continue doing and addressing. Not just in, you know, some arguments are made in the courtroom, some in the parliament, and some, in executive offices and bureaucracies. Those arguments continue to be made, and they need to be made.
Thank you very much, Samir, and thank you very much to all of you for attending and speaking and enlightening all of us in these matters. And enjoy the rest of your day, and hope we can have another discussion sometime soon. Take care. Thank you.
Thank you.
Thank you.